Good morning everyone. This is the first of our new case law updates by video, which hopefully will enable you to access case law updates in different ways and therefore stay up to date with case law. Today's update concerns the cancellation of contracts made in a consumer's home or place of work, etc. Regulations 2008, and specifically the meaning or definition of excursion within those regulations. The case that we're looking at today is that of Ozlem, Kupeli and others against Cyprus Turkish Airlines and Atlas Jet. That case was before Justice Slade this year in the Queen's Bench Division. Now at the moment there is only the Lawtel summary available, and the full judgment, once it is available, will no doubt repay further reading in order to consider the way in which these decisions have been reached and for any other particularly useful aspects which Justice Slade may have dealt with. Now within the claim there were a total of 669 members of the Turkish community who live in North London who sought refunds in respect of contracts for air travel. It appears that those 669 people contracted with the first defendant for flights. The first defendant then found themselves in financial difficulty and therefore made some form of arrangement with the second defendant. I assume, on the basis of the information that's on Lawtel, that the second defendant didn't honour those contracts for air travel and therefore the claimant sought refunds. It appears that the claimants were all attendees of their local community centre, apparently called a Samivi, which is in London, and the centre itself sought legal advice from solicitors. Therefore a meeting was arranged between some of the consumers and the solicitors, which took place in 2012 at the community centre, at which time the CFAs were signed. It appears from the Lawtel summary that judgment was entered at some point. That judgment must have been set aside and there was an order for costs for one or the other defendants to pay the claimant's costs of setting aside judgment. And I assume that the reason for assessment relates solely to those costs of obtaining and setting aside judgment. Now it comes on for assessment apparently before a master who decides that the 2012 meeting brought the claims within the ambit of the 2008 regulations, because it had been organised by the solicitors away from their business premises and was therefore an excursion within the meaning of Regulation 5. It appears that no notice of right to cancel had been given to the claimants at the time that the CFAs were made, and therefore they were held to be unenforceable. Understandably, I suppose, the claimants appealed that decision, and on appeal it was held by Justice Slade that the word excursion had to be given its broadest possible interpretation in order to reflect the intentions of the regulations, which he considered was to protect consumers from high pressure salesmanship by reference to previous decided cases. Now in Justice Slade's view, the mere fact that the consumers travelled to meet a trader away from the trader's business place didn't necessarily render the consumers vulnerable to high pressure salesmanship. He says that had that been the case, the regulations would have simply stipulated that they applied whenever a contract was not signed on business premises. So the fact that the contract is made somewhere other than the solicitor's office doesn't necessarily mean or bring that particular contract within the ambit of the regulations. The regulations, or more to the point, Justice Slade notes that the regulations refer to both to an excursion and a visit within Regulation 5, i.e. a visit to the claimant's home or place of work or that of another person. And so he decides that a very different meaning has to be given to each one, and says that given its ordinary meaning, excursion had a degree of organisation, and the fact that the solicitor had travelled away from his offices did not necessarily mean that it amounted to an excursion. In his view, the meeting between the consumers and the solicitors had been held at the community centre because it had been anticipated that there would be a large number of people that would be there. If it had been possible or sensible or practical to arrange that meeting at the solicitor's offices, then no doubt they would have done so, and then it would not have amounted to an excursion. In his view, the community centre was not going to be a place that was oppressive to the consumers, and in all likelihood would be the exact opposite, a place where they would expect to receive support and where they would not feel under pressure because they would have the support of all those other people and the people that presumably run this centre. On that basis, he decides that the 2012 meeting did not bring these contracts within the ambit of the regulations. the regulations didn't therefore apply and the CFAs were enforceable. So what does this mean to us? Well, from our perspective, it's a very useful case because, of course, it goes in the claimant's favour, deciding that the regulations don't apply and that the CFAs are enforceable. Further to the training that we did previously in relation to these regulations, this would appear to be an example of a type of case or contract that falls within neither the 2000 or the 2008 regulations. So definitely, if you have a concern as to whether your file or claim falls within the ambit of the regulations, then do have a look at this case. If you're concerned that it does, but we appear to be non-compliant, then once the judgment is available, I anticipate that there will be various supportive arguments that could be founded upon this case, given its purposive construction of the regulations, and also, of course, have a look at this case if you're feeling a little bit cautious about the type of advice you need to give, because above all, we have to identify whether or not we think that any particular file falls within the ambit of the regulations, and secondly, whether we think that the solicitors are compliant, and thirdly, we have to then give them advice as to how we see that situation, whether we think they're compliant and whether we think there's anything they can do about it. I would, however, also sound a note of caution in how we use this case and the amount of reliance we place upon it, because at face value, and again only looking at the information which is available on Lawtel, it does seem to be open to question as to whether it's been properly decided. A great deal of emphasis seems to be placed on the definition of excursion by Justice Slade. The concise Oxford Dictionary defines excursion as a short journey or ramble for pleasure with a return to the starting point, or alternatively a digression or a deviation from a regular path. To my mind, it's obvious why the regulations would use the terms both visit and excursion. Visit is used in the context of a meeting at a particular place which the regulations know, i.e. the home or place of work of that consumer, whereas the use of excursion is within the context of a scenario that the regulations don't anticipate the exact place in which that meeting may take place. And that would appear to explain why there are two different words, and of course they do have different meanings, but that is more within the practicalities of these meetings themselves. It also seems at face value that this is exactly the type of situation which the regulations could be expected to deal with meetings or contracts being made, i.e. it's taking place with a great number of people at a venue which is not the solicitor's offices, and to which the solicitors will arrange for these people to attend. So on that basis, it does seem to be open to doubt as to whether this has been correctly decided. So just again, a note of caution to sound when we're providing advice to the clients, to make sure that we do give very rounded and well-informed advice. So thank you for your time today, and hope you have a brilliant and productive day. Look forward to more video case law updates to come. Thank you.